Hello everyone, welcome to Shorthand Battle. I am Divya and I am going to dictate you a legal passage of 500 words at the speed of 105 words per minute. So get ready for the dictation. 3, 2, 1 and go. From a plain reading of Rule 9 of the rules, it is clear that in the first place, under Rule 9 Clause 1, the petitioner is entitled to claim all amounts representing the value of service and labor and profit thereon by way of deduction. The deduction is thus allowable in entirety, subject, of course, to its due verification without any limit or restriction to a percentage or proportion to the amount received or receivable against the work contracts in respect of which such a deduction is claimed. However, another method for computation of such deduction is provided under Rule 9 Clause 3 of the rules. It is subject in its application to 3 alternate preconditions, one of which must be found attracted before the method of computation of deduction of value and labor and service and profit thereon may be applied. Read together normally under Rule 9 Clause 1, deduction on account of value of labor and service and profit thereon is to be allowed at actual figures claimed by any assessee. However, a rule of exception is contained in Rule 9 Clause 3 which comes into play either if the assessee does not show separately the value of labor and service and amount of profit accrued on such labor and service, or the accounts maintained by the assessee are not worthy of credence, or if the assessee does not maintain any accounts. Plainly, Rule 9 Clause 1 and Rule 9 Clause 3 cannot and they do not apply or operate simultaneously. Rather, Rule 9 Clause 3 applies only if the application of Rule 9 Clause 1 is excluded on account of presence of any of the 3 preconditions mentioned in Rule 9 Clause 3. Here, in this case, no information, material or fact or reason has been recorded to establish the satisfaction of any of the 3 preconditions of the applicability in Rule 9 Clause 3 in as much as it has not been alleged by the assessing authority in the reason to believe recorded by him that the petitioner had not maintained its books of account or that they were not worthy of credence. On the contrary, while the reason to believe recorded by the petitioner's assessing authority is absolutely silent on this issue, in the original assessment order dated 30th April 2013, it had been categorically recorded by the petitioner's assessing authority that the books of account had been maintained by the assessee and the same had been examined by him, whereafter a finding was recorded by him as to the figures of sale of steel and cement. In addition thereto, the assessing authority, while making the original assessment order, had also examined the contract documents specifically in respect of payments to be made therein and observed that the payments for labor charges and supplies were provided to be made separately. Thus, the third alternate condition for application of Rule 9 Clause 3 of the rules clearly and admittedly does not exist, that is, it cannot be alleged that the petitioner had not maintained the books of account. Stop.